Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business law in Florida and US immigration. So if you plan to immigrate to the United States or you are already in the United States, we can assist you with all your immigration needs regardless of where you are or where you plan to go in the United States. Today we are going to speak about options to stay in the United States for those children on E-2 visa who are about to turn 21 and age out of their dependent status. But before we get started on today's topic, please subscribe to our channel by clicking the bell button or the subscribe button. So you are on an E-2 visa and then your child is on an E-2 visa as well, but they are about to turn 21 years old and age out of the E-2 dependent status. What options do they have? This is the question we are going to discuss today. Now, the same concept applies to those dependent children who are in the United States on an E-1 visa. Once they turn 21, they will age out of their dependent status. To be clear, the day your child turns 21 is the day they lose their E-2 dependent status because they are an adult for immigration purposes. And that is regardless of what it says on the I-94 record or their E-2 visa. The day they turn 21, they age out of their dependent status, and in order to stay in the United States, they need to seek another visa on their own. But they cannot be an E-2 dependent and continue to stay in the United States. And now we are going to explore what are the options for the children on E-2 visa who are about to turn 21 and age out. 1. Apply for an F1 student visa. Many children on E-2 visa are already in the United States attending a college or a university, so one of the natural ways is to actually change status or obtain an F1 student visa. 2. Apply for an E-2 investor visa for them to become the main investor. The capital can come from the parents, but one of the challenges with them becoming an E-2 investor at such a young age is showing that they are in a position to direct and develop the enterprise. However, this is not a limitation as long as you can present a very strong case. We have had successes in the past with children who became investors for E-2 visa purposes. The requirements to obtain an E-2 investor visa is the same for any other E-2 investor visa. 3. Apply for an E-2 employee visa. Another viable option is for the child to work at your E-2 company or another E-2 company where the child and the owner share the same citizenship. Now, one of the limitations with this type of visa is that the E-2 visa for employees is for managers, executives, or essential employees. And a child at the age of 21 in most cases have limited experience when it comes to management or executive, but they may be able to still qualify as essential employees of an E-2 business, including your own E-2 business. 4. Apply for a TN visa for Mexico and Canada only. If your child has Canadian citizenship or Mexican citizenship, then they can apply for a TN visa, but only if they have one of the professions listed on the TN NAFTA list, currently known as USMCA list, and they have a job offer from a US employer. Self-sponsorship through your own company is not permitted with the TN visa, so they cannot start their own business in the United States and obtain a TN visa. They will need to have a profession from one of the listed professions and also a job offer from a US employer, and meet the requirements for the job offer and also the profession that is listed on the NAFTA list, or currently known as USMCA list. 5. Apply for EB-5 Immigrant Investor Green Card for the entire family. So you can apply for an EB-5 green card, which is an investment-based green card for your entire family, and before your child turns 21, and everyone may be able to get a green card. This is why it is very important to start the process of obtaining a green card much earlier than close to their 21st birthday. Now, the current investment amount for the EB-5 green card is $800,000 for projects located in rural or high unemployment area, also known as TEA zones, or $1,050,000 for projects in urban or low unemployment area. One important aspect to mention is that the EB-5 green card category has prioritized projects in rural areas and infrastructure projects, so the processing times are much smaller than those for projects in urban or low unemployment area. Also, high unemployment area projects are receiving expedited processing. Another important aspect is that the EB-5 green card category is current for most countries, so most individuals will be able to file for adjustment of status if they are in the United States in E-2 status at the same time as they filed the main petition for the EB-5 green card for them, for the investor and the entire family, so spouse and children under 21. 6. You as the parent can apply for an EB-1C green card, and if approved, your entire family members can obtain a green card. Now, the EB-1C green card category is for executives and managers of multinational companies, so those companies that have operations in the United States and at least to one other country, to transfer from the foreign company to the US company. The US company must be in existence and doing business for at least 1 year in order to qualify for an EB-1C. Business owners can also qualify for EB-1C, so if you own or co-own a multinational company, then you can also qualify for EB-1C. We have successfully transitioned E-2 visa holders to an EB-1C green card, so it is possible to apply for the EB-1C green card if you have a foreign company and then you open a new company and you have another US company that has been doing business for at least 1 year. You can qualify for EB-1C green card as well. You do not need an L1 visa or an H1B visa in order to apply for an EB-1C green card. Now, premium processing is available at USCIS for the EB-1C green card category. So for an additional fee, you can obtain a decision in as little as 45 days. The EB1C green card category is typically current, meaning that you concurrently can file an adjustment of status if you are in the United States with your main EB1C petition, or you can apply for the EB1C petition, and after it is approved you can file for adjustment of status for you and your entire family. The EB1C green card category is a lot more advantageous than the PERM EB2, EB3 because it does not require a PERM labor certification, and also you can obtain a decision in as little as 45 days, and this visa category is typically current, as I said, so you can file for an adjustment of status if you are in the United States. Aside from these options, other options that may work for your E2 child can be an O visa, an L visa, an E3 visa that is for Australian citizens, but that would depend on your personal circumstances. These are all the options that are the most popular, but there may be other options, as I said. That is why it is important to contact an immigration attorney to review your circumstances and your case and see what can be done for your child that is aging out of their E2. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.